You're live.
All right, good morning. This is Senate Health and Welfare, and it is May 20th. We are looking at a proposal of amendment on S63 as it came to us from the House. And Jen, maybe just tell us what the amendment is.
Great. Good morning, Jen Harvey from the Office of Legislative Counsel. The House proposal of amendment on S63, which is an act relating to modifying the regulatory duties of the Green Mountain Care Board, is two instances of amendment. It is not a strike all. The first is a topic that may be familiar to this committee. This is in section 7. There had been language in the bill as introduced that then was removed, and then the House was then proposed to be and is proposed to be put back in, which would specify that the board's review, establishment, and enforcement of hospital budgets should not be construed to be a contested case. So there's a different process that they use and have been using, and the board is wanting to codify that. So that is the first instance of amendment, and it does that in two places by adding a specific language at the beginning of the budget review section, specifying that this is not a contested case, and that anyone aggrieved by a final board action, order, or determination can appeal pursuant to the board's general appeal statute in 18 VSA 9381. And then they keep the same date changes for the hospital fiscal years to accommodate the Brattleboro Retreats calendar year fiscal year. And then at the end of the section, strike language that's a little confusing in the existing law, but it was taken from originally the BISHCA, now DFR review statute that says hospitals may appeal any decision in this subsection, which is the enforcement subsection of the hospital budget review statute, to Superior Court as opposed to Supreme Court. The part I find confusing is this existing reference to the standard of review being as provided in Title 8, which is the commissioner of DFR's standard of review. So that is sort of out of sync in the existing law.
So in a practical sense, what do these two proposals do?
So these two proposals make an official determination that nothing about the hospital budget review process is a contested case, not even the enforcement piece, which is the part that is currently in litigation. The way I've sort of been describing it in a shorthand is parties are entitled to due process. They're not necessarily entitled to choose which process they would like. So the board is asking you to make the determination that it is not a contested case is not the process that they must use.
Okay.
The second instance of amendment is changing the effective dates slightly. And this is to make some changes in section 5 relating to the ACO, Accountable Care Organization certification and budget review. And if you remember, the section itself makes changes because of the expectation that the state will likely only be certifying Medicare only ACOs going forward once OneCare winds down, at least for the foreseeable future. So this has the certification piece not take effect until January of 2027. And then the rest of the provisions around budget review and everything else that changed in that section would take effect on January 1st of 2026. This is to allow the board to roll out the implementation. And that's it. I do have another version for you that shows the changes in context to the extent that that is.
So essentially saying that hospital budgets are not subject to contested case. They can't.
Right. Contested case is a specific kind of series of requirements in the Administrative Procedures Act, which is the statutory creation. So the board has had, and my understanding is, and there are folks from the board here if you have questions, but my understanding is that the process the board has always used is their standard appeals process in statute. And it is only in the last year or so that there has been a question about whether the contested case provisions of the Administrative Procedures Act should have been followed. Instead, there is litigation occurring on that would not be affected by your change here, because this would only be prospective, but it would make that determination.
So if the appeal were a contested case, if it were a contested case, the appeal would go to Superior Court, or would it go to Supreme Court?
So my understanding, and I'm gonna defer here in a moment to Mike Barber from the board, but is that before a contested case gets to court is the appeal of the outcome. So contested case is the way the hearings themselves are conducted. It's more of an adversarial process. I believe the contested case process is what they use or similar to what they use in the health insurance rate review, where there's rules of evidence apply, there's cross-examinations. And then if a party is unhappy, the language of the existing statute says they go to the Superior Court, and the standard of review is as it is for the commissioner of DFR.
That's helpful.
But I would also want to give an opportunity, if you would, to the board to explain the practical differences, because they're the ones who operationalize this.
So what the board is saying, and looking back at Michael, is that rules of evidence in the adversarial process does not adhere to the budget process.
That's correct. For the record, Michael Barber, General Counsel for the Green Mountain Care Board. Every year, the board establishes budgets for the hospitals. Hospitals are required to operate within those budgets. If the hospital's performance deviates substantially from the budget, the board can take certain corrective actions. We call that budget enforcement. So there's establishing a budget, and then there's enforcing a budget. And historically, the board has used a similar process for both of those regulatory functions. And it's a very transparent process. It involves obviously hearing from the hospitals, hearing from the healthcare advocate, and deliberating and making a decision in public at public meetings. And basically what this language does is allow us to continue using that public process for both the establishment of a budget and enforcement of a budget, and then changes the venue for appeals, because hospitals have the right to appeal. Changes the venue for enforcement appeals from the Superior Court to the Supreme Court, which I have not heard any opposition to that at any point in the process. I think I've heard from the hospitals that generally makes sense to them.
So if there is an appeal, then under the conditions in the proposed amendment, the hospital could appeal to the Supreme Court
Yes, which is where, oh, sorry.
after the order is given.
Yes.
So there's still an appeals process here.
Kind of.
All right. Sam,
Do we know if there's any particular reason why we didn't get this language when we had the bill in the first place, and why was that?
we did.
Did.
Oh, wait,
It was in the bill as introduced.
Okay.
And then there was, at the time, there was a proposal, I think, I don't want to describe who it was from, I don't recall, but to take it out. And so you put in a new section 7 that did not have this language.
and if,
And then in the House, there was a request to look at
I
it.
think we sort of ran out of time with this one. So I don't know how folks are feeling. Got questions, other questions?
Yeah.
Jen?
It's still an appeal. It's
There's
just
still an appeal,
procedure.
Right.
but it takes it out of the contested case process, which includes rules of evidence and an adversarial relationship. We're trying to build,
This has always been more of a public discussion.
right, this is a public process with the healthcare advocate, et cetera. So straw poll, folks, would you like to concur with a proposal that came to us from the House? Raise your hand if you'd like to concur with a proposal from the House. If you'd like to disagree with that and not, raise your hand.
I do both.
No, you cannot do both. That's confusing the people on Zoom. So you raised your hand, yay?
Yeah,
Is that
yeah.
true? Okay, that's good.
I'm just curious to remember why we took it out in the first place.
Well, we can talk about that. Yeah. Okay, so we are now, I think we're good. I'll present this on the floor today. hopefully we'll get to it. And we'll be set. Thank you, Jen.
All right.
Thanks for your time. Thank you, Mike. Diane.